Our next case is State v. Valentino. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
5 minutes, please.
All right, I'll note that. Counsel, I will, because I'm through the time up here, attempt to let you know when you get like a minute left in your time.
Perfect.
So
Thank
you know you're running low at that point in time. The arguments are being recorded, so when you come up, please make sure you introduce yourself for the record. Please stay behind the podium because they're both visually and audio recording you, and that will let us hear and see you well if you're there.
Thank you, Your Honor.
If there are any children, minors, or victims that you need to refer to during the argument, please refer to them by the initials or some other term like the victim, something else that does not use their name.
Understood, Your Honor. Thank you.
With that, the judge has read your brief and I'm ready to proceed whenever you are.
Thank you, Your Honor. May it please the court, Your Honors. My name is Pierce Walker. I represent Nicholas Valentino, the appellant in this case. Your Honors, before I begin, I'm not remiss to note the sensitivity of the nature of my appeal, as what I'm asking for isn't fact-dependent upon what happened at trial, but it's more fact-dependent upon what happened with the judge in this case and the behavior and whether it's appropriate for a judge to interfere with motions being made. Your Honors, I indicated in my motion that in the civil world, deadlines matter. If you miss a motion to dismiss, you miss a summary judgment, you miss a complaint answer, you could be looking at malpractice because the deadlines matter. They are the civil rules of procedure. The criminal rules also have the same sentiment. They need to matter. In this case, Your Honors, the facts of this case I did not argue on, and so to the state's credit, I know there was concern that am I arguing a manifest way to the evidence to overturn it? I am not. I am solely looking at the speedy trial rights issue in this case. The procedural history of this case, Mr. Valentino was arrested on October 17, 2023. His trial would not be held until March 19, 2024. That is 154 days. On March 19th, our case was set for trial along with 3 other cases. I was the trial attorney on that case. So I've seen this case from beginning all the way through the appeals. On March 19th, I raised to the court, once we were told that our case would be going forward, I raised a motion to dismiss for a violation of my client's speedy trial rights. According to State v. Bromley, I made a prima facie case sufficient to the court that it required the state to respond. I went through discovery tolling provisions. I went through our motion for the grand jury transcript, our motion for change of venue. I went through every tolling factor I could think of, Your Honors. And I gave the state every credit possible. And still we struggled, we were outside of the 99 days. My client was incarcerated, and so the 3-to-1 statute would apply to my client. And so rather than 270 days, we were looking at 90, and we were past that.
There was some, at least the state seems to allege, at least now, that he was incarcerated on another case or not this case. Is that correct or not? And is that in the record?
That is correct. And you are correct, Your Honor, that now they raise it. Because when I made my motion under State v. Bromley, the burden was shifted to the state. And the court, being the gatekeeper of justice, would be neutral, impartial, unbiased, unfettered by what everyone's arguing, and listen to the arguments. The state's response, and I know you have the transcript and I cited to it in my brief, but in simple terms, was not prepared. I think he stated, I'm at a disadvantage. I don't know the numbers like Attorney Walker does. I imagine the numbers are correct. There is a complete concession by the state, lack of preparation. And at that point, rather than this being what I might say in a civil term is a default, I then had an awkward exchange with the court where I found myself, and again, I'm extremely respectful to the court of your position that we are looking at a judge's behavior, but my concern, Your Honors, was that I then had a debate and argument with the court where the court's creating arguments. Court's creating arguments about a hearing that happened in January, trying to say there was a continuance sought by the defense, which was never raised by the state. So we're seeing arguments that are created sua sponte by the trial court. At that point, the trial court granted her own arguments and overruled my motion to dismiss. We proceeded to trial the next day. Next morning, the state presented its case into the afternoon. At the end of the state's case in chief, I again raised a motion to dismiss for the violation of the speedy trial rights. The prosecutor at this point indicated that he's had the night to review it, and he doubled down on the court's argument about some continuance in January, and I had to correct the court and say, I have the transcript here. I'm looking at it. My response was, as soon as we can get in as possible. And for context for the court, in January we were set for trial, along with 3 or 4 other cases, and we were not the oldest case. And so you can imagine as a practitioner, it's a little bit of a problem to say you come to court, you sit for about 4 or 5 hours wondering if your case is going to be the case that goes forward, that you prepared for, your witnesses are there for, to be told that you're not going forward because another case is going forward. At that point, the court indicates that they will be needing a continuance because this other case was going forward. For the record, and I think it's very, very critical, my client nor myself never sought a continuance in January.
Well, there's in the tolling statutes, there is a basis for continuance, trial court's continuance for a reasonable time.
Correct.
So your dispute here, I think from what I understand, is that this wasn't reasonable. You understood there were 3 trials that day, we can't go forward, okay? Your position is this wasn't reasonable to go from January to March or whatever these dates were.
Correct, and I think what's interesting is, I indicate on the court, my schedule is filling up. It's the beginning of the year. That's an honest response from an attorney as we're looking at scheduling. Mine's filling up, but the key comment that I made was, I would like to get in as soon as possible. We never went through the usual scheduling procedure of, okay, how does everyone's February 1st look? I'm busy. How does everyone's February 9th look? I'm busy. We didn't go through that. Instead, I get set just for March 19th and told, that's your trial date, have a good day.
And
so
that
March
was
19th.
and that was at the time when she was rescheduling.
Correct, in January.
Okay.
And so that was my concern was, this isn't a continuance, that we went through multiple dates. There seems to be a defense by the court that Attorney Walker sought a continuance. I never sought a continuance. The state even doubles down on it in their motion and says, well, that continuance argument. So
My sense of what they were saying is that you were asking for a continuance because you weren't available right away after that date.
correct. And what's interesting is, where's the evidence that I was not available? Where's the evidence that the court said, let's look at January 30th, and I said, I'm not available? That would be evidence that Attorney Walker's unavailable
Counsel.
of why we're bumping this.
Counsel, I'm sorry to interrupt you. Did you object to the new date?
I did not object to the new date. I think I indicated if that's as soon as we can get in, then that's what I will take. We're kind of at the mercy of the court on that schedule.
What does that mean in regard to a speedy trial? If
I don't believe
the attorney knows when he or she is in court that the trial court is sitting outside of the speedy trial.
Well, what's interesting is the docket and the transcript indicates that. I asked, is that still within my client's speedy trial rights in January? And I said, I came to court for trial that day, not thinking that we're in the speedy trial rights violation because my math was we're still within the time. So I wasn't thinking, well, here's his deadline and it's gonna be March 9th is the issue. I asked the court in January, would this put him outside of his speedy trial rights? The state did not have a response, the trial court did not have a response, but I did inquire. So to your question, Judge Carr, I do believe that there was sufficient evidence that we challenged the extension as asking, is that the only date you have? And is that gonna put my client outside of his speedy trial rights? I then raised it again after the state's case in chief, and I got the same answer, denied. Now this is where I think it gets a little curious procedurally, because my client was convicted, and the conviction order came on the docket. Shortly after the conviction order is docketed, the court dockets its own order in which it then docketed a denial of my motion for speedy trial rights that was raised. After the order is docketed, that matter should be deemed closed. The order's there, the matter's closed. The state then later, the case is over, my client's convicted, an order's on the docket denying the motion for speedy trial rights, the motion to dismiss. The state then files a supplemental motion in which now it wants to create brand new arguments. They don't ask for leave, they don't ask for permission from the court to do so, and we in fact filed a motion to strike that supplemental motion as it's improper procedurally. And again, if the procedure doesn't matter, someone needs to let me know. If the procedure and deadlines don't matter in the criminal justice system, let me know. And that's going to change the way that as practitioners and litigators, we are going to handle calendars.
One, there's about a minute left, and you're making that argument, and I appreciate it. But also, and I don't blame defense attorneys for doing this, you wait to the day of trial to file your speedy trial right because it gives you the most time to say there's a violation. Understood, but it puts the prosecutor in a bad spot. They're not prepared to respond that day. wouldn't they still have some time to respond, file a response after your motion came in?
If they asked for leave, all the prosecutor had to say on March 19th was, Your Honor, can I have 5 minutes to check? Can I call the prosecutors who are also on this case with me? Can I call my clerk, my paralegal? Can I have leave to look into this? And at that point, I wouldn't have objected if you're not prepared, but that's exactly the issue I have here. I mean, Benjamin Franklin said, failure to prepare is preparing to fail. And the same thing should apply to prosecutors. So we filed a motion to strike that. It was unopposed. At sentencing, I had to ask the court, can you please adjudicate that motion? The answer was, I don't have to rule upon it, and if I don't rule upon it, the answer is no. I had to file an additional motion to say the rules of superintendent require that you rule in 180 days. 5 minutes after that motion's filed, it's denied.
Counsel, let me interrupt you, okay? I know you're passionate about this, and I was the same way when I was an attorney as well with my cases. But I guess what I wanted to know is, in regard to this speedy trial motion, you say the court could have given the prosecutor 5 minutes. What if the prosecutor said, Judge, I need to look into this, we're gonna have to continue the trial? Wouldn't that have been reasonable?
I'd be curious what would happen in that case. It's not what happened here.
I understand, I'm asking you, what
Right,
you think,
so I
what you
appreciate the
think should happen.
hypothetical. I appreciate the hypothetical. My concern is, in that situation, if the court said I need a continuance, I would object to the continuance. I came to trial prepared. I came to trial prepared to review all components of this case. The prosecutor should be held to the same standard. And my other concern is the fact that we have a judge stepping into the shoes of a prosecutor to make arguments for the prosecutor to defeat a motion to dismiss. That's a concern. This idea of this 2-to-1, 2 against 1 in the criminal system is a problem. And it's what I saw in this case. And so I'll reserve the rest of my time for rebuttal, Your Honors. Thank you.
May it please the court, my name is Stephanie Zaranek, and I'm from the Medina County Prosecutor's Office representing the appellee, the state of Ohio. The trial court correctly denied the motions to dismiss for violation of speedy trial rights. As you were discussing with counsel, one of the crucial points here is that counsel agreed to the March 18th trial date. The trial court had
you're stating an opinion that he agreed. What is in the record that he agreed?
He says, if that's the soonest, then I will take March 18th.
Okay, so, that's acquiescence, I'm not sure that that's necessarily waiver. So, do you have any case law that said he had the responsibility at that point to say, Judge, you can't set it at that time because that'll be outside the speedy trial limitations?
I don't have any case law to support that, Your Honor.
Shouldn't that be the state's responsibility if it's outside of the speedy trial right to say, hold on, Judge, that's outside of the speedy trial right, we're the gatekeeper of that, and certainly the defense attorney's job to say, hey, this is outside the speedy trial right, and my client could have been dismissed, okay, could have been dismissed, but I want to warn you, you need to move early, because that's certainly zealously representing the client by correcting the court that the mistake the court will make the client.
Yes, Your Honor. I think that in this case, the fact that there were trials scheduled for not only the trial date that he had, but also the next trial date is a key factor. They also said that the next 6 weeks, there was a possibility that the same thing could happen again, that they could come forth for trial and get bumped for another trial. So, while the prosecutor's office certainly, had some responsibility, I think, in looking into the speedy trial rights, it's also the defense attorney's job to make sure that everything is up to date and working okay. Like you said, there's waiting as long as possible until you can to delay the trial for speedy trial rights. But in this case, counsel indicated that he was pretty slammed in January and February, and he did say that he would take March 18th as the next available trial date.
So I want to make sure I understand. When he was first set for trial, the state's position was, when there was 3 cases set at the same time, the state's position is that was within the speedy trial time period.
Yes, it was, Your Honor.
Okay, but the March 18th date, was that the date, that was the date that, you're saying that everyone agreed to, but the court set it for, that was outside the speedy trial statute?
No, it was not, Your Honor.
Okay.
Even with all the tolling events removed, he was still brought to trial within the 270.
Right, and that's your argument now, but what I'm saying is if you took all that stuff aside, would it have been outside the time period?
I don't believe so, Your Honor. I'm not entirely sure, but
The reason I'm asking you is this, is because, one of the arguments you just made is because of the fact that the court sets 3 cases down, you don't know which one's going forward and so forth, and so you have a chance of getting continued. So it seems to me like you're arguing that, well, that was within the speedy trial time period, so that's not a problem, and if the court continues, it doesn't really matter as long as it's a reasonable continuance.
I think that's correct, Your Honor.
Okay, so what happens the next time the court comes in and there's 3 trials set and it gets continued again and it happens again and it happens again? I mean, I understand you've got the constitutional at some point, whether that's speedy trial or not, but that doesn't seem quite reasonable either, does it?
No, it doesn't, Your Honor, and I think that, in this case, the fact that the trial court found it was a reasonable continuance in its journal entry, I know counsel has made some reference to an unlimited continuance. I don't think that's the case because that would be reasonable. But there is no case law in addition that states that the state must immediately rebut the assertion of violation of speedy trial rights. And the state did rebut the assertions after he renewed his oral motion to dismiss on speedy trial grounds. The supplemental response that counsel mentioned provided the Medina Municipal Court judgment entry showing that Valentino had been held on other charges and specified that only 14 days had not been told, which is the correct number, I believe.
You do agree at the trial, the assistant prosecutor did seem to indicate that the defendant has met his prima facie case. At
Yes.
trial. Now you're saying no, but at trial, the assistant prosecutor said, yeah, that seems to have met the case.
That seems to have been the case,
Okay.
yes, Your Honor. Yes. I believe that he did make the case for the speedy trial violation, but as the prosecutor said at the time, he was not prepared to do the calculations. I don't believe that the state ever agreed that counsel's calculations were correct for the speedy trial violation. And so then there is the fact that the calculations were outlined on the record, but as I stated in my brief, there were several different tolling events, a motion to reduce bonds, several motions that I believe counsel mentioned for a grand jury transcript for similar things. And so when the trial court did toll the time from that January 8th hearing until the March 18th trial, it brought up revised code section 2945.72C, E, and H. And those include any delay that's necessitated by lack of counsel, which the trial court seemed to feel was the correct response to the fact that counsel for Mr. Valentino stated that he could not be available between January and February, essentially. Any motion that was made by the accused, which he filed about 10 motions, I believe about 3 to 5 of them had been ruled on at that January 8th hearing. And then any reasonable continuance granted other than upon the accused's own motion. And the trial court did issue a journal entry before that 270-day period was up, stating that there were reasons for that continuance, and that's a Supreme Court case, State versus Mincy. As for his constitutional right to a speedy trial, the Barker versus Wingo factors would come into play. However, the delay between the indictment and the trial must be presumptively prejudicial for those factors to even apply, and delays have generally been found to be presumptively prejudicial as they approach 1 year. The time between service of summons and trial here was 137 days, not nearly long enough to be presumptively prejudicial, and so the Barker factors don't have to be considered.
About 4 minutes left of rebuttal time, Council. Please, Rick.
Your Honors, I want to address two issues. And first, I apologize if my passion is coming across a little too much.
Never apologize for your passion. We appreciate you're here to zealously represent your client.
Thank you, Your Honor. Your Honor, first, I want to address something that counsel stated regarding there's no case law that indicates when the state has to respond when the defense makes a motion for speedy trial rights. Respectfully, I find that argument nonsensical. The State v. Bromley clearly states if I make a prima facie case on behalf of my client, the burden shifts to the state. I believe in Justice Scalia's approach to reading that as interpretive as immediate. It's we're in the moment. What's the delay? A week? 2 weeks? An hour? There's no delay even asked. Instead, the actual quote is, I've got to count these days up and look at the tolling events. You didn't do that before we were there. That's your job as a prosecutor, to represent the state of Ohio, to protect the Constitution and your speedy trial rights. That's his burden. Once I make my prima facie case, which they've now conceded I did make, it shifts to them. Their burden is I've got to count these days up and look at the tolling events. It's done. Why the court then decides to step in and say, let me help create some arguments here?
Well, the court has a
is the
problem here. I will point out to you, and I'm not necessarily defending what the court's doing, but if the court, as I recall from the statute, is going to dismiss the case against the state, they have to make findings of fact as to why. So they have to engage some process. They just can't say, motion granted. They have to engage in a process in which they go by these statutes and go and look at everything, see tolling event, not a tolling event. So they have a little bit more requirement than a lot of other motions where they just roll yea or nay. They have to make specific findings in this statute they dismiss.
And I agree with that, Your Honor, and I mean that respectfully. My concern is that's not what the transcript shows. That's
And I
not the
appreciate that
court's
argument, that they were going beyond that
Correct.
role, and in your view, they were, and as you said, being a prosecutor in a row.
And that was my concern. And so that's part one. I mean, that's the first time that it's raised. I raise it. There is this argument that the response to an oral motion with no warning, the statute does not require that I have to give warning. As everyone in this room has already indicated, defense attorneys wait to get the most time encapsulated as possible for me to make that argument. So why would I make it 2 weeks before trial if trial's not happened yet? We don't know if we're actually going. As this court indicated, there could have been another continuance. Based on the way that their policy is here in Medina County of scheduling 4 trials at the same day. That is my first concern. This supplemental motion issue, I do believe, is a procedural issue that they do not want to address. They do not want to address that they did not ask for leave, that the briefing would be closed, the order's out. So think about the precedent you're setting that an order comes out adjudicating an issue or a topic that was raised by motion by me, and we're just going to allow supplemental pleading afterwards. Why? To cover themselves for appeal. You look at their brief, they don't want to argue what the prosecutor said on March 19th in real time. They don't want to argue what's said at the end of the case in chief. They want to rely upon a supplemental pleading that's filed after an order's already issued. They didn't even respond to the motion to strike. So they want to rely upon something that is procedurally inaccurate. And again, my concern, Your Honors, is if procedure doesn't matter in the criminal justice system, that we're only going to highlight it in the civil context, we need to know that as defense attorneys.
So
Because we follow the rules.
So counsel, so your argument is that we should not consider that supplemental filing at all. And if we look at just the record without the supplemental filing, then we're gonna find that there's no determination that you're speaking, that the state was within the speedy trial statute.
Yes, Your Honor, I would ask Judge Carr that you would disregard the supplemental pleading, that you would find in favor of our appeal on the motion to strike should have been granted, as it was unopposed and it was after a pleading and there was not a motion for leave sought, because I would have opposed the motion for leave, the case is over. And I would ask that the court would find in favor of the appellant on the motion for speedy trial on March 19th, both times, before trial, at the end of the case in chief, and the prosecutor's not prepared. If prosecutors don't have to be prepared, we're setting a slippery slope precedent here of just file supplemental motions after and cover yourself for appeal purposes.
And counsel, your time is up. If you would briefly conclude, if you have anything else to say in conclusion.
Thank you. Your Honors, I appreciate your time today. I appreciate the sensitive topic, and I meant respect with the court here in Medina County. I'd ask the court to really look at the case, really look at what happened in this case, and at this time I would ask this court to grant our appeal and overturn the decision to deny the motion to dismiss for a speedy trial right. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of courts and also be available on the Ohio Supreme Court website. With that, I'd like to thank both of you this morning for your presentation on behalf of the court.